Mr. Miller, what we're here for today is what's known as an arraignment, okay? Which is not a bond setting, but is very similar. The purpose of an arraignment is what's known as a formal advisement of your rights as well as what you've been charged with, okay? All right. Now, Mr. Miller, you've been charged with 2 offenses, the first of which is murder. In South Carolina, that carries a mandatory minimum of 30 years and does carry up to life as well as the possibility of death. It's a most serious as well as a violent crime and is a no parole offense. Do you understand that charge? And before we get started, and this goes for everybody, these charges are allegations at this point. The warrant or the ticket in some of your cases are allegations of what that means is you're innocent until proven guilty. The state bears the burden of proof to prove your guilt beyond a reasonable doubt, okay? So anytime I refer to the charges, they are just that right now. They're charges, okay, and allegations, all right? You understand that that is the first offense that you've been charged with today, okay? Your second offense is for armed robbery, which is, again, a general sessions offense, meaning that both of these charges will be handled in general sessions court, which will not be here, okay? Your court date has been scheduled for January 26, 2015, okay? Now, that is not your trial date. However, that is the first date that is a mandatory court appearance required, okay? If you do not show up for that court date, bench warrant will be issued for you. However, in an arraignment, I am not allowed to set bond at this time, okay? So, what I'm here today for is to advise you of your rights, as I said, as well as what you've been charged with, okay? Your bond will be set at a later date by a circuit court judge, okay? All right? Now, because you've been charged with both general sessions offenses, you have not only a number of rights, the first of which is, as I just explained, you have the right to plead not guilty. You have a constitutional right to plead not guilty and ask for either a jury trial or a bench trial, okay? Your second right is that you have a Sixth Amendment right to counsel, which means that you can hire your own attorney to represent you, but you may, and in this case, since you will be remaining in the detention center, you would most likely qualify for a public defender, okay? This is the application for the public defender. It can be completed while in the detention center, and it can be returned to the clerk of court's office to determine whether or not you get a public defender, okay? Additionally, you have the right to request what's known as a preliminary hearing. Now, a preliminary hearing is a hearing to determine whether or not probable cause existed at the time of your arrest. You would not be able to present any evidence or testify for yourself. However, your lawyer would be able to cross-examine law enforcement about the nature and circumstances of your arrest. Do you understand that right? Okay. And additionally, if either of these charges or all of these charges are dismissed and all prosecutors are found not guilty, you have the right to have these charges expunged off your record. Do you understand that? Okay. Anything further at this time that you want to ask me because of the nature of these charges? Now, keep in mind, we're not setting bond at today's date. My job is to inform you when your court date is, which is January 26, 2015, and that you've been charged at this time for the offense of murder as well as for the offense of armed robbery. Okay? Yes, ma'am. Any things you want to say?
Just would like to advise the court as well as Your Honor in reference to the family being here showing their love and compassion for their loved one, Mr. Herring. We do understand that it is just an arraignment, but we would like to express the fact that they would like to be a part of every part of this trial, and just to know that they are dearly in loss of their loved one.
Yes, ma'am. Thank you.
Thank you, Judge.
Is there anything, investigator?
No.
Okay. All right. Now, Mr. Miller, the charge of armed robbery is an offense that it would be possible for me to set bond on today. However, since I'm arraigning you on the murder charge, I'm going to keep both of those charges together and in the discretion of the circuit court judge. So you understand that your bond will be set at a later date. All right. Thank you, sir.
Thank you, Judge.